Alright people, so welcome to Jumbo IS and welcome to our daily current affairs lecture series in which we cover a particular day's current affairs within 30 minutes. Now needless to say this, you have to make this lecture series a part of your daily routine because through that you'll get a hold over current affairs. And I need not tell you or explain to you the importance of current affairs. 50% of your UPSC paper, whether it's prelims or mains, is from current affairs, and you need to have some hold over these current affairs. And you can do that if you make current affairs coverage a daily habit of yours. And through this lecture series, we will precisely help you do that within 30 minutes, right? So make this lecture series a part of your daily routine. All right then, enough of the introduction, let's straight away dive into today's lecture. But first, let's take a look at the list of topics that we shall cover today. Okay, so let's begin. So daily current affairs, 12th of August 2026, and here are the topics. Topic number 1, should UPI remain free? Because recently the government has made an amendment to a particular law through which UPI transactions won't be free anymore. Up till now they were free. There were no charges on making UPI payments. But now there will be. And why is it a good thing? We'll talk about this. Then topic number 2 is digital universities in Punjab, because Punjab has become the first state to bring a law to allow digital, completely online universities. So we'll talk about this concept. Then we'll talk about lie detector tests, because recently Supreme Court made an important observation with respect to tests like these, lie detector tests, how police can use it, can they be used as evidence in court? It is important for us to know. And in the end, we'll talk about Kerala to Keralam, because Lok Sabha passed a bill amending the name of the state of Kerala to Keralam. Okay, now you need to be aware of the entire procedure, the constitutional provisions with respect to name change, okay, and what procedures are involved and what historical root is there with respect to this word called Keralam. Okay, why the state of Kerala decided to go for the word Keralam. Okay, this is very important for us to know. So these are the 4 news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is, should UPI remain free? Now listen to me very carefully, okay? Up till now, UPI transactions were kept completely free. You didn't have to pay any charge for sending or receiving money, okay? No charges were there. But now that won't be the case. And this is a good thing. Now why? Why was UPI kept free so far? Well, the government wanted to promote online transactions, okay? That is why they kept UPI free. How did they keep UPI free? Well, whenever you go to buy something from any shop, okay, and you make payments through a debit card, right? The shopkeeper gives you that POS machine, you swipe your card in it and you pay the amount for the item that you have bought, okay? Now that payment, at least 2 to 3% or 1 to 2% of that transaction, well, has to be paid to banks. But that payment is not made by you, it is made by the shopkeeper, okay? So suppose you bought something worth ₹1,000, okay? You made the payment. Now 10 rupees or 20 rupees on that transaction would be paid by the shopkeeper to banks as payment fee for this transaction, okay? This is known as merchant discount rate, okay, MDR. Now UPI was kept free from any merchant discount rate, and the reason was simple: government wanted to promote UPI. But people were criticizing the government for this. Why? Well, there is no such thing as free. There is no such thing as free lunch. If you are not paying for UPI, well, someone else is. And in this case, the taxpayer was paying for UPI, because you need to maintain this huge digital public infrastructure called UPI so that it functions seamlessly without any technical glitch. But now the government has said that merchant discount rate shall be applicable. Okay, this is the gist of the matter. Now let's investigate, let's dive a little deeper. Okay, so let's begin. So should UPI remain free? So this was in the news, okay? Now UPI has completed 10 years and it has many achievements. Those achievements are given in your notes, so do check them out. Now it has been recognized by IMF as the world's largest retail fast payment system by transaction volume. In fact, UPI handles nearly half of all global real-time digital payments. But it was kept free from any merchant discount rate, okay? But recently, the government has passed Taxation and Other Laws Amendment Bill, and they have removed this provision. Earlier, merchant discount rate was kept 0, okay? For RuPay debit card, government wanted to promote this. Government said that, well, MasterCard and Visa are foreign payment gateways. government wanted to promote its own debit card or payment gateway. So for RuPay debit card, there was no merchant discount rate, and for UPI transactions, there was no merchant discount rate. Okay, but now the government has removed this provision. And what are the reasons given by the government? Well, they said that we need money. For what? For sustaining the infrastructure that is working behind round the clock 24/7 to make UPI possible. So we need that, because otherwise, well, the banks were suffering. They had to pay a lot of money, banks and many other payment operators. Then fund heavy cyber security. We want UPI transactions to be cyber proof. So we need to fund cyber security. So we need money for that. Plus, for UPI to be operable, okay, because now more and more people are joining UPI, Google Pay and Paytm. That is why we need cloud infrastructure, data centers for this. So we need money for all of this, and you cannot ask banks to fund this entire cost, okay? Now is the time for merchants to step up, okay? Remember, you and I don't have to make that payment. The shopkeeper has to make that payment, okay? Makes sense? Now, the zero MDR dilemma. Why was it criticized? Okay, and why the government has decided to change zero MDR, and now there will be significant MDR, around 0.3 to 0.9% of the transaction. Okay, why zero MDR was a bad thing? Remember, I told you in the beginning that charging some money for UPI transactions is a good thing. So why we need to know this, that why zero MDR was bad. To accelerate digital adoption post demonetization, the government inserted Section 10A into Payment and Settlement Act, legally banning MDR on RuPay debit cards and UPI transactions. But that was a problem. Why? Because the people who are operating UPI, that is National Payment Corporation of India and banks and many others, payment operators, well, the annual operating cost for processing UPI transactions reached nearly 15,000 crores. Now, who is paying for these 15,000 crores? Not you, not the shopkeepers. Well, the burden was taken up by banks, okay? Because you need money for servers, data storage, fraud checks, cyber security. So this was there. Then, as per the 32nd report of Parliament Standing Committee on Finance, they said that because there is not enough money with banks to maintain these servers, well, people have reported a lot of technical glitches in UPI transactions. Plus, the quality has to be improved continuously. For that, you need money, okay? If you need to stop technical glitches, you need money for that, right? So why do you need money? As per this Parliamentary Standing Committee, there is already financial strain on banks and financial technology firms. Then you need to prevent, this lack of money was preventing platform upgrades. You need to continuously upgrade your UPI platform so as to keep up with technology. Well, for that, you need money. Plus frequent technical declines, technical glitches were happening. People were not happy with, their transactions used to get blocked. Then government wants to deploy AI in UPI for cyber security and cyber fraud, anti-fraud AI. For that, you need money again. So these are the reasons. Hence, Parliamentary Standing Committee, which includes opposition party members as well, they have said that, well, nothing is for free. There is no such thing as free lunch. So charge some amount. But we also want that this burden should not fall on consumers. Otherwise, consumers would stop making UPI payments and they would go back to cash. Okay, so the burden would fall on, well, let's take a look at this new framework, key features of this new framework. Okay, the law is known as taxation and other laws. And the burden would fall on, well, not consumers, merchants, shopkeepers. Now you'll ask me, what about transactions between me and my family members or friends? Well, they are completely exempt. Zero cost for consumers, all P2P, peer-to-peer, between you and me. Transactions are free. Only merchant transactions would be priced. Exemption for micro merchants. Now, if you are buying a packet of Uncle Chips or Lays from a small Kirana shop, those transactions are also exempt. In fact, transactions less than 2,000 are exempt from any merchant discount rate. This is there. Only large entities like big e-commerce platforms which have an annual turnover of at least 50 crores, well, they have to pay this cost, merchant discount rate, and even for them, it is kept at 0.3 to 0.9% of the transaction cost. So if you're buying something worth rupees 1,000 from, well, let's suppose Amazon, then 3 rupees would be charged, so on and so forth. Okay, so it won't put any significant burden it won't detest people from, it won't persuade people to leave UPI. UPI will still be popular, but their government has found a mechanism to make payments. Okay, not make payments, basically fund UPI infrastructure, right? Now, we need to do more with UPI. So government already has certain reforms in pipeline for UPI 2.0. Already there is market concentration. There are so many app providers, private third party app providers like Google Pay, Phone Pay. So the market is already very crowded. Therefore, National Payment Corporation of India, which handles UPI, well, they have put caps on minimum capital. Okay, only people with certain threshold of capital are allowed to be third-party app providers. Then government wants to integrate credit with UPI. You can access micro loans from UPI. Then financial inclusivity. Government has brought in UPI 123 Pay, UPI Lite, which works offline, and UPI 123 Pay works through voice commands. So, this app can work on phones which are not smartphones, because voice command can make a transaction. So this would enable financial inclusivity, because there are certain people who lack proficiency in English. So this is there. And conversational AI and e-mandates. Okay, AI and translation related AI, again, to make voice-based commands in UPI better. So this is the thing, right? Now, way forward, well, government needs to use this money to fund technical infrastructure. Government is using UPI as a tool for diplomacy. Government is exporting this, okay, to countries in need. So this is good. And government needs to invest heavily, because now more and more people are online. Government needs to invest heavily in cybersecurity and consumer trust, because if there are enough cybersecurity scandals with respect to UPI, well, people would shift back to cash, okay, and government wouldn't want that, right? So this is the thing. That's all you need to know about this news item, right? Now let's quickly shift our focus to another fascinating news item, and that is digital universities in Punjab. Now, as the name suggests, digital universities are what you are already thinking in your mind. These are completely online universities. You can complete your degree without going for a single day in your college. These are online universities. Now, Punjab has become the first state in India to have a legal framework for these online universities to work, digital universities to work. Clear? The thing is that Punjab government is saying that we are doing this to make education more accessible, people don't have to travel, okay, affordable, accessible, all these things they are saying. But opposition party members are criticizing this policy. Why? Well, these online universities are being established by big edtech firms like Physics Wala and all. So, well, opposition parties are saying that this government has sold education to edtech, big private edtech firms. So they are cornering the government on this point. Then the other point is that some people are saying they have gotten a little technical. Some technical critics are saying that the law is in complete violation of UGC guidelines, University Grants Commission. Okay, how UGC allows online learning, then how this law of Punjab is in violation of UGC? We have to investigate this matter, right? So let's begin. So digital universities in Punjab. So Punjab Vidhan Sabha or Punjab Legislative Assembly passed 3 laws: Cloud University, Hoshiarpur Bill, MS Digital University, Patiala Bill, and Physics Wala Digital University, Patiala Bill. Okay, so these are 3 digital universities that are being created through 3 separate laws. These acts operationalize Punjab Private Digital Open University Policy. Okay, making Punjab the first Indian state to establish a dedicated legislative framework for private, fully digital open universities. Clear? Now, if you need to know the timeline of this entire issue in Punjab, well, here it is. So, Punjab Digital University's legislative framework, policy basis, Punjab enacted a policy in 2026. As per that policy, they enacted these 3 laws. And what would be the governance architecture? Well, certain basic points are: the education will be 100% online, okay, degree delivery, self-financed. So, look, all these colleges and universities receive grants from government. So they charge fees from students, but they also receive grants from government, and that is why they are financially sustainable. Punjab has said that these online universities would be self-financed. They won't receive any grants either from Center, University Grants Commission, UGC, or state. And governor shall act as visitor and can make changes so as to keep oversight over these digital universities. Okay, so government will have some hold over these universities. Statutory UGC compliance. Punjab government says that our law is UGC compliant, but critics are arguing otherwise, right? Now, first, let's talk about the core features of this policy in Punjab. Okay, so there are 6 to 7 core features. First of all, 100% digital delivery. You need not go to the office of that digital university or any place, any offline. I mean, no offline visiting is required. 100% at the comfort of your own home, you can receive a degree. Then, minimal physical footprint. You see, government has certain guidelines when you have to establish a university. Your land should be minimum 10 to 15 acres and so on and so forth. In this case, the government is saying, well, you just need 2 to 3 acres for online classrooms, studios, okay, data servers, and that's about it. You don't need more land. Self-finance, you won't receive any grants from the government. And it is completely under National Credit Framework and Academic Bank of Credits. Whatever degree you'll do in this digital university is transferable to any offline university. So for example, you started a 4-year course, you completed 2 years, you receive credits for that. Now you want to go to a particular college, so you are transferring your college to an actual offline college. You can start your course from 3rd year because you would have received 2 years worth of credit from this digital university. I hope you understand the meaning of this word credits. This is as per new education policy. Then any AI content in these online lectures or online notes shall be flagged. The university people should make it clear that this particular content is AI generated. Okay. And student protection guidelines are there. Plus there is a domicile quota. 15% of the seats in these online universities would be for Punjab residents, Punjab domiciled people. Plus, the governor of Punjab shall act as a visitor, can make changes, keep an oversight over this university, right? Now, where is the conflict? The conflict is with UGC. Okay, that's where, well, the critics are technical critics. I'm not talking about regular political opposition party critics, technical critics. Okay, now, as per UGC 2020 rules, okay, which allowed online education. Well, they have said that no online degrees will be imparted for engineering, medicine, nursing, and PhDs. Because UGC feels that for these degrees, you need to go to a college. You need offline classes and offline experience. So for these courses, online degrees won't be provided as per UGC 2020 rules. But as per Punjab, well, engineering degrees can also be provided. Okay, so this is a big conflict. Then quality and commercialization. This is a political criticism. Opposition alleges selling education to edtech firms, neglecting state universities. So first of all, you are neglecting government universities, promoting private universities, and you are selling education to these universities for a hefty sum of money. So this is the thing. And legislative harmonization. Punjab state claims that we are compliant with clause 4B of UGC 2020 guidelines, which says that, well, online degree courses should be allowed. But these same guidelines say that degree courses shouldn't be provided for this. Plus, they are saying, Punjab is saying that we are compliant with NCRF, okay, what is NCRF? National Credit Framework. And we are completely in compliance with new education policy, which was enacted by Centre. And as per new education policy, online education should be boosted and online education should be promoted because it increases accessibility, okay, remote learning. So Punjab is saying we are correct, right? So this is the conflict. Now, what is the way forward? It is given in your notes. It's very simple. If Punjab is going forward with this plan of digital universities, it needs to take care of certain things. First and foremost is quality of education shouldn't be compromised, okay? And by the way, there is also a table in your notes which compares offline universities with digital universities, okay, with respect to government regulations. So, well, here's a table. Go through this table, though I don't think any questions would be asked from this, but still go through it, right? That would be all. That would be all as far as this topic is concerned. Now, let's quickly shift our focus to next news item, and that is lie detector test. You must have seen this in movies, web series, shows, foreign shows, that, well, investigative agencies, when they are investigating against a particular person accused of a certain crime, they ask him to go for lie detector tests during the course of an investigation, or polygraph tests, or many other form of tests, right? Do you know that these tests are not considered evidence in Indian courts? Now, if they are not considered as evidence in Indian courts, then how are they allowed in India? That's question number one. Question number two is, well, this particular, not question, but to give you some context, why lie detector tests were in the news, it's because people accused of neat paper leak. The charge sheet has been filed against them, the police has filed, they have completed their investigative process. Now, these people are saying that we want to prove our innocence and we are ready to go for lie detector tests. The Supreme Court has categorically denied them this. Okay, the Supreme Court has said the investigation is complete, the charge sheet has been filed. Okay, I know why are you asking for lie detector test. You want to delay the case, and we won't allow you to delay this case. That is why we are not allowing you allowing you these lie detector tests. And well, lie detector tests are not your rights. Okay, so now the important question for us is, what are the legal mechanisms, or as far as law and order is concerned, investigation is concerned, criminal justice system in India is concerned, what is the status of these lie detector tests, polygraph tests? You need to be aware of them, okay? Because it involves Constitution of India as well. So let's talk about this, okay? So lie detector tests. So why were they in news? Well, because neat paper accused people asked for lie detector tests, okay? To prove their innocence. The Supreme Court has said the investigation is complete, so we don't want you to delay the investigation. So charge sheet has been filed. Now, you need to know this. You know, these lie detector tests, polygraph tests are important. Important for whom? They are important for investigative agencies. They are important for investigation. You must have seen a lot of detective shows, okay, foreign as well as an Indian. So it is important. But do you know what? To conduct a lie detector test, you cannot force a person to conduct a lie detector test. You have to take their consent. Okay? The Supreme Court has made it clear that without the person's consent, you cannot force a person to go for lie detector or polygraph test. Plus, whatever is revealed in that lie detector test cannot be used as evidence. And why did the Supreme Court go for this? Well, the Supreme Court said that the reason why we want lie detector tests to be voluntary, not compulsory, is because the Constitution of India does not allow for that. Okay, so Article 20, Clause 3 of Indian Constitution says no one shall be forced for self-incrimination, which means no one can be forced to testify against themselves. Okay, plus Article 21, right to life and personal liberty. Well, Supreme Court has opined that invading someone's mind through these polygraph and lie detector tests, you are breaching their mental privacy, which is completely violative of their fundamental rights, so it is not allowed. And if you want to go for lie detector tests, you have to take the accused person's permission. Clear? This is the thing. Now, well, you might think that no self-incrimination is given as this is a fundamental right. Yet, the police can force a person to give their fingerprint or DNA sample for investigation. That can be forced, but not lie detector tests. Why? No self-incrimination should mean no self-incrimination. Well, the answer to that was given by Honorable Supreme Court in Selvi versus State of Karnataka. Okay, they said, the Supreme Court said that, well, fingerprints and all these things are allowed. Okay, they are covered under Indian Evidence Act. They should be allowed. But mental privacy is sacrosanct, and therefore lie detector tests are not allowed unless they are voluntary. Clear? What all did the Supreme Court say in Selvi versus State of Karnataka? The legal jurisprudence surrounding lie detector and forensic tests in India is anchored in Supreme Court's 3-judge bench ruling. So they said, total bar on compulsory administration. You have to take that person's consent. That is mandatory. And, well, these lie detector tests, these polygraph tests, these are mental evidence. You are searching a person's mind. Okay? This is completely different from physical samples, DNA sample, fingerprints. Fingerprint DNA samples can be forced, but not this. Because fingerprint and DNA samples are already covered under Section 53 of CRPC, which was earlier which was later replaced by section 34 of BNSS. So physical samples are not considered part of no self-incrimination, but this is. Therefore, well, consent should be taken. And Supreme Court has defined how will you take this consent. First of all, this consent will be taken in front of a magistrate, judicial magistrate. Then that person shall be accompanied by his lawyer who will explain the pros and cons of this. And he should make an informed free choice, not under compulsion. There should be no policeman around him forcing him mentally or physically. These are the prerequisites. Plus one more thing. Do you know whatever is discovered? Okay, remember this. Lie detector tests have no evidentiary value. Whatever is discovered in a lie detector test, so much so, if the person confesses that he has committed murder in a lie detector test, okay, then too that confession cannot be treated as evidence as per Indian Evidence Act or Bharatiya Sakshya Adhiniyam, the new law. That is not admissible in the court. Then why do we conduct lie detector tests? Well, the courts have made it clear. Well, these lie detector tests can be done to aid investigation. So, for example, while questioning, the police gets to know the location of the murder weapon, the location of something else, and they retrieve that murder weapon. That murder weapon can be presented as evidence, but a confession in a lie detector test won't be admissible as evidence. You understand the distinction, right? This is clearly mentioned in Bharatiya Sakshya Adhiniyam, which replaced Indian Evidence Act. So this is there. Clear? Make sense? Now, well, in your notes, I've given a table of these different types of mental tests like polygraph, brain mapping, narco analysis, where they drug you and ask questions, and DNA and biometric sample, the physical samples, which is admissible. Okay, so a proper comparison is given in this table form in your notes, so do read this. Most of these things have been already discussed by us, so do go through this as well. And now, let's quickly shift our focus to last news item of the day, and that is, well, Kerala will now be officially called Keralam because the Lok Sabha has passed a bill. Now that bill will go to Rajya Sabha, and if it is passed over there, the president will give its assent and Kerala would be officially called Keralam. Now, what is important for you to know? What is the procedure, the constitutional as well as the legal procedure to change the name of a state? Okay, which article of the constitution covers that? What is the process? You need to be aware of that. Clear? So let's begin. So Kerala to Keralam, and why are we discussing this? Because Lok Sabha passed Kerala Alteration of Name Bill by voice note. The legislation seeks to officially alter the name of the state from Kerala to Keralam. Okay, and this would amend first schedule of the constitution, because first schedule of the constitution lists down the name of the states and UTs. So you'll be amending that, right? Now, what is the procedure for changing the name? Remember, if you want to change the name of a state, change the boundaries of that state, you will have to look towards Article 3. All the changes made to the territory of a state or name of that state, well, these changes are made as per the provisions of Article 3 of the Constitution. And what are these provisions? Well, first of all, generally, well, the concerned state will pass a resolution, but this is not compulsory. The Constitution says that the state need not pass any resolution and the center can do it on its own, suo motu as well. Now, once there is a proposal, well, the Union Cabinet will give its approval and ask for ministerial NOCs. NOC, no objection certificate from Ministry of Railways, whether changing this name would add any administrative cost to you, Ministry of Shipping, all these things. So you ask the opinions of different ministries. Once that is given, then you have to introduce a bill in either house of the parliament. That bill cannot be introduced without the previous permission of the president. That is required. Once the president gives its permission, then you can table this bill in either house of the parliament. Okay. Once you table that bill, okay, the president can ask for the opinion of the concerned state. Okay. The president president will ask the opinions of the concerned state legislative assembly, but the president is not bound by the opinions given by state legislative assembly. The matter goes to Lok Sabha or Rajya Sabha. Lok Sabha passes it, Rajya Sabha passes it by simple majority, 50% present and voting. Once it is passed by both houses, it goes to the president gives its assent, and the name is officially changed. That's what happened in case of Kerala also. First, Kerala Assembly passed a unanimous resolution in 2023. Then Union Cabinet and Ministry of Home Affairs gave NOCs and clearance. Then, well, the President made a reference to Kerala Assembly for its views. Kerala Assembly gave its views. Then they tabled the bill in Lok Sabha. It has been passed by Lok Sabha through voice vote. Then it will go to Rajya Sabha, then to the President for final signatures. Okay, and then once the President gives his assent, first schedule shall be amended. Clear? This is the procedure which you should be familiar with. But what are the historical and etymological, I mean the root of the word Keralam? What are the historical reasons behind this, or historical evolution? You see, the thing is that the word Kerala is a little anglicized, okay? But the evidence of this word is found as back as the time of Ashoka, because rock edicts of Ashoka mention three southern kingdoms: Chola, okay, inscription of Ashoka, pillar edicts or rock edicts, Chola, Pandya, and Kerala Putra. Okay, now we all know Kerala Putra are the same as Chiras. Now there is a German linguist who says that the word Keralam and Cheralam, Ch and K, can be interchanged. I mean the root can be interchanged. Okay, why? Today they can't be interchanged, but they say the time when it began, the word began, well, it could have been interchangeable. Okay. Well, the thing is, he says, that German linguist says that Chera means unified and Alam means home, unified home. So he made an assessment, this German linguist, that right from Gokarna in Karnataka till Kanyakumari, this entire coastal land was, well, Kerala Putra, Kerala Putram. Okay, this is there. Then, well, there is another historical movement, Ekaya Kerala movement, unifying. Okay, so when India got independence, well, Kerala was divided into three parts. There was the princely state of Travancore, okay, Cochin, and Malabar district within Madras Presidency, which is today Tamil Nadu. So there was this movement called Ekaya Kerala movement, which said that we need to unify all the Malayalam speaking areas into one single state. Okay, this was Ekaya Kerala movement. They asked for combining these three areas because these three areas are Malayalam speaking. And when in 1956 State Reorganization Act was passed, well, their demand was accepted. So this is the history of Kerala, by the way. Okay, now what is the significance of this name change for India and India's unity? First of all, linguistic and cultural alignment. Well, it adheres to a simple principle that the culture, or well, the federal linguistic parity, state identity should reflect local heritage. Keralam name reflects that. So Kerala's state identity would reflect its local heritage if it's named Keralam. So this is there. Then Kerala has said that the name Kerala should be amended in all languages. All languages, English, Hindi, should use the word Keralam to describe Kerala. So they have said that all 22 languages in 8th schedule of our constitution should be, I mean, they should amend their words for Kerala. They should call it Keralam, so that nobody uses the word Kerala anymore. And yes, there would be some financial and administrative costs because many government papers, government departments would have to change that name. But that is there. I mean, it always happens. And in your notes, we have also given a table of previous name changes. Like Orissa was converted to Odisha. Uttar Pradesh was once called United Provinces. So there have been many name changes. Okay, Uttaranchal was converted to Uttarakhand. So there have been many name changes. Those examples are also given in your notes. Right? That would be all. So with that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. But it will add more value if you're number one, consistent and regular with this lecture series. And number two, you revise this lecture from the notes provided by us. That is really important. On that note, I shall take your leave with the promise of seeing you again with another set of news items. Thank you, everyone.